Welcome to Part 2 of 15 of this educational quizzer designed to enhance understanding and recall of the revised Corporation Code of the Philippines, encapsulated in Republic Act No. 11232. This quizzer is intended as a study aid for law students, accountancy students, and financial management students, who will benefit from testing their knowledge on key provisions of this pivotal legislation. The revised Corporation Code sets out the legal framework governing corporate structures, activities, and governance in the Philippines, making it essential knowledge for future professionals in legal and financial sectors. This quizzer will cover various aspects of the general provisions of the revised Corporation Code, including the requirements for corporate names, registration, incorporation, the role of the Commission, and the special considerations concerning corporate governance. See our playlist for all the reviewers involving corporations. 1. What are the grounds for the Securities and Exchange Commission, SEC, to disapprove the Articles of Incorporation under Section 16 of RA 11232? The SEC may disapprove the Articles of Incorporation for not being compliant with the Code, including if they are not in prescribed form, have purposes that are unconstitutional, illegal, immoral, or contrary to regulations, have false capital stock certification, or fail to meet Filipino ownership requirements. 2. Under Section 17, what criteria must a corporate name meet to be approved by the SEC? A corporate name must be distinguishable from any name already reserved or registered, not protected by law, and not contrary to laws, rules, or regulations.
3. What actions can the SEC take if a corporate name is found not distinguishable or contrary to regulations according to Section 17? The SEC can order the corporation to cease using the name, require registration of a new name, and remove all physical uses of the old name. Non-compliance can lead to contempt, administrative, civil, or criminal liabilities, or revocation of registration. 4. What does Section 18 require for a corporation to commence its existence? The incorporators must submit a corporate name for verification and, if approved, submit articles of incorporation and bylaws. The corporation commences existence upon issuance of a certificate of incorporation by the SEC. 5. What defines a de facto corporation under Section 19? A de facto corporation exists when there is a good faith claim to incorporation under the Code, and its corporate powers cannot be inquired into collaterally except in a quo warranto proceeding by the Solicitor General. 6. What is the liability for acting as a corporation without authority under Section 20? Persons acting as a corporation without authority are liable as general partners for all debts and damages incurred, and cannot defend against such liabilities by denying corporate existence. 7. What are the consequences of non-use or continuous inoperation of a corporate charter as per Section 21? Non-use for 5 years results in automatic revocation of the certificate of incorporation. Continuous inoperation for 5 years may lead to delinquent status and potential revocation unless remedied within 2 years. 8. How long are directors and trustees elected for according to Section 22 of RA 11232? Directors of stock corporations are elected for 1 year, and trustees of non-stock corporations for up to 3 years, with both serving until their successors are elected and qualified.
9. What is the requirement for the proportion of independent directors in certain corporations under Section 22? At least 20% of the board must be independent directors in corporations with significant public interest, including those regulated under specific financial laws. 10. What voting rights do stockholders and members have during elections according to Section 23? Stockholders can vote the number of shares they own, and use cumulative voting to allocate votes among candidates. Members of non-stock corporations can vote for as many trustees as there are to be elected but cannot give more than one vote per candidate. 11. What must happen immediately after the election of directors as per Section 24? The elected directors must formally organize and elect key officers such as the president, treasurer, and secretary, and comply with the requirements of their roles as prescribed by law and the bylaws. 12. Can the president of a corporation also serve as the secretary or treasurer? No, the same person cannot serve as both president and secretary or president and treasurer at the same time, per Section 24. 13. What happens if the corporate officers do not comply with the SEC's requirements after a name dispute? Non-compliance can lead to contempt charges, administrative, civil, or criminal liabilities, or revocation of the corporation's registration as per Section 17. 14. What are the qualifications for an independent director under Section 22? An independent director must have no relationships that materially interfere with the exercise of independent judgment in carrying out responsibilities of a director. 15. How is a corporate name verified for distinctiveness according to Section 18? The SEC verifies that the proposed name is not already reserved, registered, or legally protected, and not contrary to laws, regulations, or public policy.